All right, the 14th session. My name is MIWashington, and I'm the judge that will be presiding over this session. The court will call the case of Michigan First Credit Union versus Gerardo Alcalca Rivera, as well as Jacob Lindsay and Ford and Spirit Ford. Case number 22C 3359.
Yes, good afternoon, Your Honor. Stephen DeLuca on behalf of the plaintiff, Michigan First Credit Union.
Good afternoon.
Afternoon, Your Honor. Michelle Harrell, appearing for defendant Spirit Ford. And for some reason, I can't get my camera to work.
I understand. Sometimes it happens.
That's crazy, but thank you. I apologize.
Gerardo Alcalca, please state your name.
Gerardo Alcala Rivera.
Thank you. All right, we're here for a pretrial today.
Yes, Your Honor.
Where are we with this, please?
So we have been in settlement negotiations with Spirit Ford. We've made some headway as far as that goes. I'm hoping to hear back from Spirit Ford here shortly. I think there's a decent chance that we'll be able to resolve this matter. We've also been trying to get the deposition of the salesperson at Spirit Ford without success. I've been trying to get that deposition for some time. However, I will acknowledge that opposing counsel Michelle Harrell was recently in a car accident, and we had to adjourn that deposition, and she hasn't been able to be in the position, and she can speak for herself, to represent her client to go forward with that deposition. So we haven't got the deposition done. I think discovery has expired, and interestingly, we just got the third defendant served, Jacob Lindsay. He was just served April 8th. Personally, I just found out, I haven't got the proof of service yet. So he still has another 21 days from April 8th to file a written answer with the court. So that being the case, I definitely want to get the deposition of the salesperson. And if Jacob Lindsay files an answer, the plot may thicken, as they say. So I may want discovery as to whatever his defenses are and what he has to say. So I know that this court is given quite a bit of time, quite a bit of discovery, but that's where we stand. And so under the circumstances, I would request discovery to be extended for perhaps another 60 days, because, like I said, we haven't even heard from Jacob Lindsay yet, to try to get this deposition done, see what Jacob Lindsay has to say in response to the lawsuit, and try to get this done.
Is that right?
Yes, Your Honor. I agree with everything Mr. DeLuca said. We will produce the salesperson. There's no question. We're very willing to do that. I was in a serious car accident. I'm not back at the office yet. But I will cooperate absolutely with Mr. DeLuca. He's been very cooperative and very professional. So I agree. If the 60-day extension is what he would like, that would be fine. Thank you.
I will continue discovery through June 19th, 2024. And then we'll have does June 20th work with your calendars for returning?
Yes, Your Honor.
All right, June 20th at the same time, 2:00 p.m.
Okay. Thank you, Your Honor.
You're welcome.
Right,
Just so
you.
everyone knows, it's probably the last time I'm going to extend discovery, so please try to make the best use of that time possible. And I understand that you have some challenges and that you're waiting for someone else to file a response or not. So I get that, but just be mindful of it, please.
Yes, Your Honor. Thank you for the.
Thank you, Your Honor. Thank
You're
you.
welcome.
All right,
Have a good day. Thanks. Bye, Stephen.
Bye.
Lake Trust Credit Union versus James McIntosh, case number 23C 3561.
Good afternoon, Your Honor. Christopher Sossin, appearing on behalf of the plaintiff.
Good afternoon, Mr. Sassen.
Good afternoon, Your Honor. Leslie Honig, appearing on behalf of the defendant.
Good afternoon, Ms. Honig. All right, we're here for a pretrial today.
Yes, Your Honor.
And where are we with this, please?
Thank you, Your Honor. I would note that there was one previous pretrial in this matter. This is the second pretrial.
It is.
And additionally, plaintiff has sent some discovery requests to the defendant. Defendant has produced some answers to those discovery requests. The parties have not engaged in any discussion or negotiation as it relates to resolving the potential pending action. Plaintiff would request that the court consider a period of time to allow the filing of dispositive motions, and then just issue a subsequent pretrial order as this case is set for trial.
Any response, Ms. Honig?
That is agreeable, Your Honor.
All right. How long do you think you'll need to file your dispositive motions?
Plaintiff would anticipate filing within 30 days, Your Honor.
And then they'll have a response time of about 30 days, so we're about 60 days out?
Yes.
All right, I'll give you the same date I gave the last individuals, but this one will be for the dispositive motion heard by date, which would be June 20th at 2:30. So it'll be the dispositive motion heard by and pretrial date, June 20th, 2024 at 2:30 p.m. Depending on what happens, we will decide where we go next from there. All right.
Thank you very much, Your Honor. Nice seeing you.
Nice seeing you. Bye-bye.
Thank you. Take care.
Looks like Keith Cox is not coming. He is. Okay, thank you. The court will call the matter of Gerner Properties and Management versus Eric Davis, Quinoa Davis, Reba Moore, case number 15C0400.
Good morning, Your Honor. Jeremy Brown on behalf of plaintiffs.
Please state your names.
Good morning. Good morning, Your Honor. Well, good afternoon, Your Honor. Keanu Davis.
Keanu, thank you. Is there anyone else here in this particular matter? Is Eric Davis or Reba Moore present?
No, it was just myself.
Having heard from no one else, we're here on an objection to the garnishments in this case.
Yes.
This is your motion, sir. It looks like you filed a motion indicating that you were objecting to the garnishment, indicating that you were away in college and did not reside there. I was age 17 to 18 years old. So
Yes. So, so like I said, good afternoon. So Reba Moore is my mother. Eric Davis is my older brother. So, I almost didn't even remember what this was about. But in 2015, I was away at college. I don't know if you guys will allow me, but I have my resume I can attach with the schools that I attended. In 2013 through 2016, I attended a school, and I went to 2 other colleges and finished my degree. So I wasn't even, the last time I was in Ypsilanti was in 2013. So the only reason why my name was on that lease is because they told my mom, the landlord told my mom that if I was to visit to come home, then my name would have to be on the lease because I was away. So I didn't even know that I was, I guess, responsible for it up until my name got, my taxes got garnished. I think they tried to take it in 2000. I think one other time they tried to take some money from me, and then I was told that my mom was fighting fighting for it also.
Mr. Brown?
From my records, that he was a co-applicant on the lease. I mean, are limited to garnishment procedures or legal bars to the garnishment. The objection is not used to attack the original judgment, so we would seek that his motion not be granted.
All right, so put that in layman terms for you, Mr. Davis. What it essentially boils down to is that the court rules do not allow you to attack the basis for the judgment that was received in the first place. You can't go back and say, I'm not liable for this at this stage of the process. This is a 2015 case. The law doesn't allow for you to go back and attack the judgment itself. Your objection to any garnishment in this case has to be based on one of the enumerated reasons that are on the objections to the garnishment form that you filled out, or some other basis that is a basis acceptable by the court rules. And the one you're objecting to, which is that you were away in college at the time and did not reside there, is not, that's attacking the original judgment that was entered against the individuals. So you can't do that after 21 days or at max a year if the court were to find that there was good cause for a year extension. That would have meant that in 2016 would have been your last time to attack the actual judgment itself. So that's the problem that you have here, is that you don't have the ability to attack it on the basis that you're saying you want to attack it on. Having said that, I do have a question. Mr. Brown, did he sign this lease?
Per our records, yes, he signed as an applicant, a co-applicant on the lease, yes.
So based on what you brought here today, sir, you don't have a basis for objecting. And I hear you saying that you did not, there was one other time when your taxes were garnished and that you didn't do anything about it at that time. You were allowing your mother to do something about it.
Yeah, it was supposed to be addressed. I mean, and the thing is, I'm 17, 18, 19 years old. Now I'm 28, I mean, I'm not asking you guys to understand, but now I'm 28 years old. I'm almost 30, so I'm understanding more how to handle business, but and I'm making more money too. So $1,500 as opposed to $20 is a lot of money. So I did allow it to be handled the way I thought back then by my mom and whoever else I thought could handle it. But this is the first time I actually understood what was going on, and even now I'm just now understanding that I don't have to sign the lease if I'm just visiting there, but my mom always wanted to make sure we had a place to stay, even if I was away in college. So it's just a lesson that I learned, but so I just want to make sure that I even tried to do my part.
So this, the amount of the unsatisfied judgment is $1,518.
Yes. And then I actually called to try to set up a payment plan with them, even though I told them, I explained the same situation to them. I was like, I didn't live there. But if you guys will allow me to set up a payment plan, I'll do that. And if you guys will release the money, and they said that they wouldn't release the money until the full balance is paid. So I just would rather handle it in court at this point. So
How much is being withheld?
I think it's $1,500.
So basically the whole amount.
Yeah. So basically I'm covering the whole balance for my mom and my brother. And I'm the only one who didn't stay there, so my mom feels horrible. So it's kind of created a big division. But and unfortunately, I'm the breadwinner in the family, so I think that's kind of why I'm the one that got hit the hardest. But so, like I said, I learned a lesson. But so yeah.
Mr. Brown, when was this lease signed that you're saying he signed?
2015.
I graduated high school in 2013 and went to college in 2013, July of 2013.
I had 2014, 2015 on my notes, but I can possibly look at the document.
Well, obviously, my concern is whether or not he's able to enter into a lease if he's only 17 years old.
Do you want me to go grab a copy of the document?
Yes, please. I'll pass this matter.
And I'm not sure if I was and
I'm
if I
passing
was,
that case. I'll call it back in a second, okay?
okay, sorry.
DNF Associates LLC versus Stephen Gisandiner, case number 21C3884. Is anybody here on that matter? DNF Associates versus Stephen Gisandiner. If so, please unmute your device, state your name at this time.
Hey, I'm sorry about that, Your Honor. I'm Stephen Gisandiner in that matter.
Gisandiner. All right, thank you, sir.
I didn't know I was muted. Sorry about that.
Thank you. Is anyone here from DNF Associates LLC? Anybody representing them? All right, it appears on April 3rd, notice was mailed with today's court date to the plaintiff's attorney, but they may not have received it in time. All right, we need to call to make sure they received it. I'm gonna pass that as well. An objection on the motion to set aside. Objection on the motion? Or is it just the motion? It's just the motion. Okay. The court will call the matter of Westland Car Care Towing versus Heather Schaefer, case number 24C0221.
Good afternoon, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Good afternoon, Your Honor. Stuart Collis, P49530 on behalf of the defendant. Mr. Cox and I unusually find each other on opposite sides on this matter.
All right, this is your motion, Mr. Collins?
Your Honor, this is our motion to set aside default judgment. As stated in the affidavit, there was a good deal of confusion regarding a retainer agreement. Ms. Schaefer thought that we were employed. We did not. That matter came to a head just after the judgment was entered. We promptly filed, of course, this motion to set aside. Actually, I tried reaching out to Mr. Cox, I believe on March 6th, once we learned that the judgment was entered. Mr. Cox did not respond. I'm sure he's got a billion other people calling, and I don't blame Mr. Cox. But we filed this motion within the 21 days. She has a meritorious defense, and this car was either sold or given to her niece prior to the fire, and we do not believe that the towing bill is accurate. So we ask at this time that it be set aside. I know I'm working with Mr. Cox and Mr. Schaefer to try and resolve this matter, either to substitute in the niece in this case or to resolve the bill. But we're going to need to do a little bit of work on the case.
Thank you, Mr. Cox. Any response?
No, Judge, much of what Mr. Collins said is accurate. He did reach out to my office. I don't have authority to stipulate to setting this judgment aside at this time. I was trying to figure out, if there could be, he could demonstrate conclusively that there was a sale of this vehicle to give me an opportunity to also potentially do that, but we haven't gotten that far. So at this point, plaintiff's position is that let the court obviously rule on the issue of good cause, and then, leave it to the court's discretion. On meritorious defense, obviously if the car was sold, it would be an absolute defense, but we just haven't seen evidence so far to demonstrate that conclusively.
Thank you. Given the arguments and the brief that I reviewed in this case, I have had an opportunity to decide that in this particular case, the court will grant the motion to set aside. There is a meritorious defense and there is good cause as to how this happened in the first place. The motion to set aside is granted. I'll give you guys a pretrial date. Does May 30th work?
That works for the plaintiff. You said May 30th?
Correct.
Yeah, that's fine for the plaintiff.
It's fine for defense, Your Honor.
May 30th, 2024 at 2 p.m. How long before you can provide an answer?
Your Honor, I could get that done in the next couple of weeks.
Answer within 14 days.
And hopefully we could get this resolved well before any of that.
All right.
Yeah,
Thank you so very much.
just tell me what you got.
As soon as I get it from Ms. Schaefer. Thank you.
Appreciate it. Thank you, Judge.
Thank you. Have a good day.
Sure. You too. Bye now.
The court will call the matter of Tidewater Credit Services versus Tika Gregory, case number 17C 2631. Is anyone here on that matter? All right, no one has appeared. I will presume they're making payments as required. Court will recall the matter of Garner Properties and Management versus Eric Davis, Kiana Davis, and Reba Moore, 15C 0400.
Good afternoon again, Your Honor. I was able to look at that document. It was signed on September 18th, 2014.
How old were you then, sir?
Pardon me?
How old were you on September 18th, 2014?
I believe on the 13th, 13th of September, I would have just turned 18.
It's a valid contract.
Okay.
So I am unable to set it aside, sir.
Are there, can I ask one more question?
Yes, sir.
So I guess with me being a resident of Novi at that point, how does that work? If
You sign the lease, you can sign leases wherever you want to sign leases. You're still obligated under those leases. So you could go around town signing tons of leases. You would still be obligated under those leases, sir.
Okay. Okay, well, thank you anyway. Okay. Well, is there any way that I can, like I told them, I'm willing to set up a payment agreement with them, a payment arrangement, but I don't want to, like, I don't feel like them taking the whole $1,500 and then we still setting up a payment arrangement. I feel like there should be at least some compromise. I don't know if you guys agree, but so like I said, I did try to set up a payment arrangement with them, and they weren't really trying to budge. So I don't know if can we work something out that way. I mean, I haven't lived in the city of Ypsilanti.
Mr. Davis, once it's at this stage, what they decide to do with respect to their garnishment is up to them. That's not something that I have control over anymore. So as unfortunate as this is, and I do understand, that's why I wanted to look at how old you were when you actually signed it. Unfortunately, there's nothing that I can do because you were an adult at the time. So if you were 17, it would have made a difference.
5 days.
Although it shouldn't make a difference because the law basically says that you can't attack the judgment. And so that's an attack on the judgment. But I was willing to listen to that despite what the law says. So there's nothing I can do at this point. Okay. I'm sorry.
Well, thank you guys. Okay, well.
I guess the good news is, I know this is probably terrible timing for you, but the good news is for the most part, this will now be behind you. And maybe, Mr. Brown, given everything you've heard today, if he were to somehow give you the additional $18, maybe you could, well, it's been so long, I guess the judgment does still exist on his record, but maybe you could help him at least clear up his credit some kind of way.
I'll make all the notes from today with everything going. I don't work at all in the collections portion of it, but I'll make notes in the file with everything. And if you want to, I'll put the notes in. If you want to contact them again, my notes will be available.
I've called Garner Properties since this started, and they've never worked with me.
Call the law firm. I don't think it's call the law firm.
Yeah, I have their number as well. I mean, like I said, I appreciate you guys. I mean,
and I can't promise anything, but I will make the notes and make everything. But yeah, like Garner's not gonna even know what's really going on. So just call the law firm, and then if they can help you, they generally try to work with people. But again, I can't. Like I said, it's like the judge said, it's an old judgment, so I don't.
Yeah. Well,
it's an old judgment, but it would affect him probably still now. But I'm not sure. Maybe it has dropped off his record. I don't know.
Well, it popped up. Okay. I purchased my home in 2020, and it popped up. So it still affects me. You know what I mean? So like, I'm a county employee. I just purchased my home a couple of years ago. It's definitely still followed me. And like I said, I've contacted Garner Properties, and they haven't been like, yeah. So like I've learned a lesson with family as well as Garner Properties. So thank you.
So, if you could please put a note in the file to consider giving him that, you could, since it's satisfied, you could do a satisfactional judgment or dismiss as to him, since these other people who are the older adults, have not accepted any responsibility for it. And he's trying to do right in his life. Maybe the fair thing to do here would be to dismiss him from the case now that it's been paid.
I will make all those notes, and I will send an email out today.
All right.
Thank you, Your Honor.
You're welcome.
Thank you.
Thank you, Your Honor.
All right, the court will recall the matter of DNF Associates LLC versus Stephen Gissendanner, case number 21C. I think he said Gissendanner. 21C 3884.
Good afternoon, Your Honor. Denise Baker, P53670 for the plaintiff.
Good afternoon. All right. Um, we have a motion to set aside the order for installment payments that was filed, and then Mr. Gissendander filed an objection to that and requested a hearing on that. Am I correct?
Yes, ma'am. I'm trying to set up payment plans. I was already in the payment plan arrangement with them, and I missed past 2-3 months. I've been going through some family issues and stuff like that. But as soon as I received the letter and everything like that, I sent them another payment because my account with them was still active and everything. And then I still went up to the courthouse and proceeded paperwork also.
So, well, first of all, it's their motion. They're here on the motion to set aside your installment agreement. You already have an installment agreement. And their argument is that you haven't been making payments under that installment agreement. In fact, this installment agreement was set up back in 2022. You paid on June 6th, and then you didn't pay again until October the 19th, missing 5 months, 4 months, somewhere in there. And then you paid for October and November. Then you didn't pay again until April. Then you missed May. You paid in June and July. Then you missed August. And then you didn't pay from September. You paid in September and didn't pay October or November. And then you didn't pay since December of 2023. It's what their argument is. Am I correct, Ms. Baker?
Yes, Your Honor, that is accurate. And he did make a payment on posted on March 26th, must be after he got our motion.
Yes, ma'am.
Everything else the court stated is accurate. Those missed payments are accurate.
Well, I think their concern is that you're not following your agreement. Is that, Ms. Baker, what is your argument today?
Yes, Your Honor. This is, I believe, not the first time we've been here on the motion to set aside installment payments. There's just been continuous neglect in making an effort to pay this judgment balance. We'd ask that the installment payment order be set aside at this point.
The balance?
$603.02.
Mr. Gissendaner?
Yes, ma'am.
Why weren't you making the payments in 2022? You told me about why you didn't make it these last 3 times. Well, what happened in 2022 and 2023, sir?
Honestly, just bad memory on my end. No excuse. I have no significant reason why. Just bad memory on my end. I'm sorry about that. Got a lot of kids be dealing with them, but that's still no excuse. If possible, I'm willing to give the account number so they can manually pull it monthly on like the 1st or the 2nd of every month until it's paid off. If they could let me get installment plans back again.
Ms. Baker, he's willing to set up an automatic withdrawal.
I don't have an objection to that. Is he able to make up any of the missed payments?
At the current moment, no, ma'am. I'm actually just tapped out because my daughter's prom is this month. So sorry about that.
Well, are we able to set up for $100 a month and get this taken care of in the next 6 months?
Can we try 75? I don't want to honestly bite off more than I can chew and then be back in the courts because I didn't pay the full amount.
I will agree to that as long as you do contact our office within the next day to set up that automatic, to get the forms filled out for the automatic withdrawal.
Yes, ma'am. Is that the same number that I call when I make the payment via card?
That is correct. And if the court would amend the order for installment payments then to be for $75 a month.
I will do that. Are you gonna prepare? Let's see.
If we could deny the motion, and is there a line on there to amend? Or we could put that in there.
There really isn't, but I'm gonna write it in and write because I'm just gonna write the parties agreed to $75 per month.
Yes, ma'am.
via direct withdrawal, or what's the best way to word that? Direct withdrawal it is.
That's fine, yes.
All right, I've signed that.
And then again, Miss, when are you going to be able to start that $75?
I get paid bi-weekly, so I need a calendar real quick, and I can get that started with the next pay cycle.
Yeah, and then we can get that on the form then when you contact our office.
All right, I'll let them know that tomorrow then, as soon as I call and set it up.
Okay, that sounds good.
Also indicating on the form, the defendant is to contact plaintiff attorney by April the 12th, 2024,
That would be perfect.
or no agreement. Okay.
Yes, ma'am.
All right.
All right, sorry about that.
You're okay, sir. Have a good day.
Thank you, Your Honor.
Bye-bye. Budget Stadium Towing versus Latoya Carroll, case number 23C0224.
Good afternoon, Your Honor. David Fancher on behalf of the plaintiff.
Good afternoon, Your Honor. Latoya Carroll.
Good afternoon. All right, I adjourned this for Ms. Carroll to get an attorney and be present here today. And there were supposed to be some exchanges made. Otherwise, where are we with this, please?
Your Honor, Ms. Carroll called me last week and asked if we could release the garnishment and later made payment arrangements. I told her we couldn't do that. And we kind of agreed that we were going to take the income tax money, pay off the judgment, refund whatever was back due to her, and then satisfy the judgment. We were hoping to get the payment last week, but instead we got documents from the state indicating, probably because they were aware of this hearing, that there was no money coming to us. And then the next day we got another disclosure saying that we are getting money, but we're not going to get the money till early May. So if we could just deny the motion with respect to the state tax garn, and I filed earlier today a release of the employer garn, and then when we get the money, we will refund whatever's left over to Ms. Carroll and satisfy the judgment at that time. And I think we could probably move on at that point.
All right, so there was a garnishment release that was already filed as to the employer.
Oh, so what I sent today, I've already sent?
Yeah, they've already entered that order.
Okay.
And the one for the employer has been removed from the docket. So the only thing left is the objections to the third-party withholding unit, which I already explained to Ms. Carroll when she was here last time, that I would give her an opportunity to get an attorney who could come and make arguments, and we would see if it went anywhere, but that has not occurred. Is there anything else you'd like to say before I make my ruling, Ms. Carroll?
Yes, Your Honor. As Attorney Ventura explained, I had spoken with an attorney in regards to the matter. Considering my situation, I actually contacted through legal aid, of which they suggested me contacting Attorney Ventura directly, which is, he stated I did, in regards to doing some type of, or setting up some type of installment payment, which he said he was not able to do at this time. So I was further suggested that with him receiving the funds, from what I was told, I also contacted the Department of Treasury, and they told me that the funds had been released. So I wasn't aware of any extension on that either. But they did also, the attorney did also mention that I request the satisfaction of judgment be placed with the funds being released from my understanding.
I'm gonna deny the order on the objections that was filed and order that the funds be immediately released to the plaintiff or plaintiff's attorney. And after they have received those, they will provide you with the satisfaction of judgment, ma'am, and return any funds that are owed to you back to you.